Good afternoon. My name is Regina Hopkins. I'm with the DC Bar Pro Bono Center, and I would like to welcome you to our webinar this afternoon on executive sessions. I am making a presentation along with Rick Marks, who is a partner at DLA Piper and has a lot of expertise on corporate matters, and I will introduce him in a second. For those of you who would like a copy of the PowerPoint, if you look at the interface with GoToWebinar, you'll see a handout which has the slides for the executive sessions. So please feel free to download them and follow along, or you can download them later on in the session. With that, I don't know if Rick wants to say hello, but in any event, welcome to the session. And like I said, I'm being joined by Rick Marks, who is a partner at DLA Piper. He has been practicing business law for more than 20 years and does a lot of work in the nonprofit sector as well. He's a member of the DLA Piper Pro Bono Committee, and he's an adjunct professor at Georgetown University. He got an engineering degree from Northwest and a law degree from the University of Maryland. So with that, I will begin the session by just saying welcome. We're going to go through the session. Feel free to email us questions in the question box as part of the interface, and we will, go ahead and answer them at various points during the session. So with that, I am going to start with a brief overview. So what are we covering today? We are covering executive sessions. And we're going to go over some of the common myths about executive sessions that people have. The first one is, do you have to keep minutes or any records of what you do in executive sessions? We'll also talk about what kind of decisions a board can make in executive sessions. Do they have to then disclose what they did in executive session, or can it remain private? And then we'll also discuss attorney-client privilege. And then finally, we'll talk about best practices for conducting the executive sessions. So with that, I will go ahead and, next slide, talk a little bit about what the definition of an executive session is. The first thing you need to know is that an executive session is a meeting or portion of a board meeting where only the board members are present. Staff and other attendees, the public, like clients, if you have you're a board of a school, maybe you have parents there, they are excluded from the sessions. Sometimes it's called a closed meeting or an in-camera session. Generally speaking, any board can go into executive sessions. The fact that you receive government funds does not preclude your ability to go into executive session. And so it is, as we'll talk about, there are times where you definitely want to go into executive session. But that's really what is defined. Now, you can have an executive session where you might have one or two staff members or key advisors who are invited to join the executive session. Those would include if you had a litigation matter that you wanted to discuss in private, you could have your legal counsel present. If you wanted to have staff members like your CEO or executive director in the session to talk about some key personnel matters or financial matters, you could have them in the session. But generally, the idea of the session is that executive session is that people are there by invitation only, and that the presumption is that only board members will be present. Typically, the board chair will call the executive session, and some other boards will allow board members to request an executive session if it's supported by a majority or a supermajority vote. And they can be called before, during, or after a regular board meeting. Sometimes you know in advance that you're going to need an executive session, like on the agenda is the CEO evaluation. So you know up front that you are going to want an executive session. Then other cases you will want something may come up in a board meeting. There may be a point of contention that comes up at a board meeting, and so at that point the board may decide, you know, this is just too sensitive a matter to discuss let's go into an executive session and discuss it then. And then the third time it may come up is, if you don't realize, for example, that one of your board members has a conflict of interest until the issue comes up at the board meeting. So at that point, you may say, look, this is something we have to handle in private. So, the fact that it's not pre-scheduled does not preclude you from going into executive session if the need arises as you're going along. Now, two things that executive session is not is it's not an executive committee meeting. An executive committee meeting is a meeting of less than the whole board. It is a member of the committee, and what it does is what you do is it's typically the officers and maybe one or two other board members. They have the right to call in if they have the right to participate and make decisions between board meetings, and so that's a subset of the board, and they act in lieu of the board typically between board meetings. And the other one is board meeting. Sometimes if a conflict of interest occurs, a board member has a conflict of interest, they may be asked to leave the meeting, but that does not mean that it's an executive session. It just means other people. You could have staff members there, you could have parents there, you could have other people there, but they're just excluded, so there's not that. So, okay. So why would you go into executive session? Well, there's a couple of reasons why you would. The first is you want to deal with sensitive or confidential topics like audits, legal matters, personnel issues. So what you want to do is deal with those types of issues in private. You're setting the CEO's compensation, or you have you have some performance issues with the CEO, and you don't want it discussed in front of other staff meetings or anybody else for that matter. There may be issues that come up in your audit. There may be other legal matters. In those contexts, like you're being sued and you want to discuss potential litigation strategies with your attorney, you want to keep those confidential, so that's why you would go into an executive session. Sometimes you just want to have candid and open conversations and to explore different courses of action, and you want to give space for people to discuss difficult or unpopular options. So it allows board members to have that freedom to speak in a way they wouldn't be if staff member are present. I was the general counsel for Habitat for Humanity, and one of the reasons why the board, it was a board that only met 4 times a year. There were a lot of people in the room when they met as a result. And so I remember one board member saying, I don't talk candidly in these meetings because I'm concerned about staff members, what they're thinking. I don't know who's in the room, so I don't talk very much. And so our board would get into the practice of every board meeting having an executive session just so board members could speak more freely about what was on their mind. The other thing you want to do is you want to be able to discuss decisions without the influence of staff or donors or others. Sometimes when you have people looking at you or making reactions or body language or something, people will, for the same reason I just discussed, they won't feel free to have the type of conversation they had if there was more privacy. So they will have to speak more candidly in an executive session. The next thing that you may have is the board may want to save space so they can talk about themselves and how they're doing as a board and whether they're communicating properly or or there are issues within the board about workflow and attendance and things like that. And it's easier to have those conversations when other people, the public or staff, are not present. So you may want an executive session so the board can talk about its own business without feeling that people are looking at them. And then finally, you may want to have an executive session to which only the CEO is invited. And this gives the CEO a forum to have candid and confidential conversations about their concerns about staffing or particular performance of individuals or other things that they may not feel that they can have with the board while other staff people are present. And the board is a great resource for the CEO. I mean, if you have a good board, they have a lot of personnel there. They have a lot of people with a lot of business judgment and expertise. You may have attorneys, you may have accountants, you may have HR professionals on the board, and it's very helpful to the CEO if they can draw on that expertise. And having a board CEO executive session allows those types of interactions to occur without having the issue of having the other staff people present and listening in. So that's another reason why you might have an executive session. So I guess my question is, Rick, are you on the phone? Okay, Rick is having some technical difficulties, so we've gone over these slides together. So I will proceed on, and hopefully we can figure out the technical glitch so Rick can join us. So what are some common topics for executive sessions? Well, with the board only, they may have an executive session with the auditors to receive direct feedback about the organization's financial health and performance. The audit is really, in its basic form, essentially an appraisal of the management, financial management of the organization. You have independent auditors coming in once a year, and they look at your processes. They're not really auditing the actual ins and outs of what is of the financial transactions, but rather they're more likely auditing the processes. And are you reconciling your accounts regularly? Is there proper documentation for expenses? Are things done in a timely manner, etc.? And so that can be sometimes, if there are issues with how the books are being kept, that can be a difficult conversation to have in front of the CEO or the director of finance. And so oftentimes the board will meet with the auditors in executive session to have those types of conversations. Another time is the annual performance of the CEO. Again, you want to have the board together to talk about what they think about the performance of the CEO. And you also, we'll talk a little bit more about it later, CEO compensation is something that a board would do only in executive session. And then, something could come up mid-year with respect to CEO performance, so you want to have the freedom to go into executive session for those issues. And then there may be legal issues that involve potentially the judgment of management, so you may want to go into executive session for that. There's another topic that you may want to do with the CEO present or not, depending on how touchy or sensitive it is, which is succession planning. Everybody comes to the point in their career where it's time to move on. And so that's something a board's responsibility is to think about succession planning, and they may want to do that, or at least have some part of that conversation by themselves. And then finally, intra-board disputes, practices, performance issues. Again, you may want to talk about board performance with only the board members. With the CEO, some common topics are staff performance and disciplinary matters. Again, this is a place if the CEO feels like they have to part company with a senior member of management, they may want to talk about that with the board. So particularly if it's someone that the board interacts with on a regular basis. Staff compensation is another one. Lawsuits and settlement discussions, if for some reason the organization is being sued, you want to know why. Crisis management, if there is some sort of crisis, bad publicity, something happened, someone stole your funds or whatever, unfortunately you're in the newspaper for the wrong reasons. That may be something you might want to have with the CEO present, but not a whole lot of other people. And you may want to do it when you have discussions of major strategic or business issues. There is a time to share that with other people, but sometimes the board and the CEO may want to talk about those while you're still, sort of sorting through ideas. Like if you're saying we may want to close down a particular program, you may want to thrash it out before you discuss it with more staff in the room, because you don't want to get them alarmed unnecessarily if it's a non-starter. So I'm going to pause here just for a second and answer a few questions. The first one is, I am not sure I am clear. When you have a full board meeting in executive session, what is that called? That is an executive session. The full board can meet in executive session. Executive session means that it's private, not that it's something less than a board meeting. There are executive committees that are committees of the board and can make decisions, but they can do that in open session or executive session. The executive session is a function of whether people other than directors are in the room at either a committee meeting or at a board meeting. And so they can be fully, you can have that. And then, let's see what other questions I have. I have a bunch. Someone asked, is it a best session to have is it a best practice to have an executive session at every meeting? And the answer is, we will discuss that a little bit later, but the answer is often yes. It may be a good idea to have one at every meeting, simply to give the board time to talk to each other. And it depends, one of the functions may be how often that you meet. Next question is, are you saying that when a board member is excluded due to conflict of interest, it does not fall in the category of an executive session? That's right, because whether or not you're in executive session is determined by whether only directors are in the room, not whether all the directors are in the room. So I may have a board meeting where a member has to not leave the room because you're voting on a matter that the board member has a conflict. That person, but you may have the staff there, you may have outsiders there. You typically won't, but you could, and that is not an executive session because other people are in the room. That is different than having a meeting in which only directors are present. That's what the executive session is. It's very frequent, as I said, it's common when you have a director conflict of interest to discuss it in executive session because of privacy issues, but it's not required. Okay, and I think we're still having trouble working with Rick. Okay, so we will proceed. Rick? Hello?
Can you hear me?
Yes, I can. Okay, so Rick, we're going to, can you, I don't know if you've been listening in, but we're going to now turn it over to Rick Marks, who's going to talk about some of the myths of executive sessions.
And my
Thank
apologies
you, Rick.
for my
no, that's okay.
Inexperience.
Okay, so our fault.
Yeah, so the first question is whether there are minutes that are required for these executive sessions. And again, nonprofits generally have to keep board minutes. There's a code section in DC Nonprofit Code that you need to keep your records. And when you fill out your 990s, they're asked to disclose if you do keep records of your board meetings. So executive sessions, like the rest of your board meeting, need to have minutes. And the minutes need to be taken care of within 60 days of the board meeting for the contemporaneously requirement under the IRS rules. So again, the question of do I need to keep minutes of executive session? The answer is yes. And now we can talk a little bit about what that really means, because we've just gone through a lot of discussion about how sensitive the topics are that are being discussed at the executive session, or excluding people from the room so that we can have private conversation. And the idea of having to keep minutes of those meetings could be counterintuitive to the idea of having executive session for some confidential or other special reason. So we can talk about what it really means. So generally speaking, a lot of organizations, when they take board minutes, they keep very detailed minutes, almost as if they were at a business meeting wanting to make sure they had all the takeaways. And that is not necessary at a board meeting. The minutes of a board meeting really need to be a summary of what was discussed at the board meeting. It does not need to be specific detail about who said this and who said that. And it's actually best practice to avoid that type of detail. The importance of the minutes is to give a summary of what happened at the meeting and to support the fact that actions taken by the board at the meeting were done so in the exercise of due care in carrying out their fiduciary duties. So if the board is considering an action to enter into a contract, or the board is considering an action to approve a lease, it certainly needs to enter into a discussion about the pros and cons, and the discussion should happen at the board level. But when you get to the minutes, we don't need to say whether someone thought the rent was too high or too low, or the strategy of negotiation. You simply need to say that the board discussed the contract and they determined it was in the best interest of the company and authorized the officers to sign it, that type of thing. So again, the board minutes really just gives the basic information that's necessary to serve the function of either approving board action or showing that the board carried on the conversation in due course so that they were exercising their fiduciary duties. Again, the idea of the minutes not being a transcript of the meeting is important. It doesn't need to be any history of the organization or something that you might see as a policy piece. This is really just a business case board meeting that's supposed to report the action. And the reason, one of the big reasons why you don't want to have a ton of detail is because minutes could be discoverable in a litigation. And so if you had a lot of detail in the minutes that was discussed at the board meeting that may not include facts that are supportive of the organization in a litigation, if you translate them into the board minutes, that could be discoverable. We'll talk a little later about attorney-client privilege, but as a general matter, a lot of these things are not going to be subject to that or could be available in litigation. So you just want to be careful about the minutes, and certainly when you're talking about things like executive session minutes, you want to be even more circumspect. So the next slide talks about executive session minutes. So this was just generally about minutes, and now we get into executive session minutes. And again, even more you need to be careful about what you write into these minutes. So you should have minutes. What will happen in your regular board minutes is your board minutes will say, now the board went into executive session. And you can say who was there and the time that you went into executive session. And then the regular board minutes will say the board, if it's in the middle of a meeting or wherever it is, the board ended executive session and the full board can reconvene. So that's what you would put in your regular board minutes to show that you went into executive session. So then you'll be taking executive session minutes, again, which you need to be very careful and only contain information that is really necessary to meet whatever legal requirement. A lot of executive session is a discussion, and it's really not a decision. We'll get to it in a second. You can make decisions in executive session, I think Regina had mentioned earlier. But a lot of executive session is a discussion about a performance issue, a discussion about a litigation issue. And if you're not actually taking an action within the executive session, you really can be very circumspect about what you write about the topic or about what was discussed within that session. But you do want to make sure that you're keeping those limited, that you're talking about the topic that's at hand. The third point here about litigation, and again, this is one area, as Regina said, you might go into an executive session if you want to try to keep the discussions more confidential. And it's important to have an attorney, the organization's attorney, in that session to support the attorney-client privilege and try to protect the discussion and any minutes from that particular session from discovery in the litigation. And again, we'll talk about it a little bit later, but this is the actual organization's attorney sitting in the room as an attorney, not the fact that some board member may be an attorney. Someone needs to be functioning as the organization's attorney, and you should have that person in the executive session if there's a discussion about litigation. Whenever you have executive session minutes in particular, we would advise that they be reviewed by counsel, particularly, like I said, if they involve litigation or a sensitive matter, because we want to make sure that if there is something that's discoverable that we can't keep out from attorney-client or other confidential means, that the minutes are not going to be a detriment to the organization. And when you do create the executive session minutes, you should certainly mark them as confidential. You should keep them in a confidential place, like the attorney's office. The distribution of those minutes should be limited to the people that were in the session, so that they're not generally kept with your general board minutes. General board minutes may be reviewed by others in the organization. They may be reviewed by members if it's a membership association, and we'll get to that in a little, but you want to try to keep those executive session minutes separate, confidential, and protected the same way you're trying to keep the content of the discussion at the executive session confidential and limited. So Regina, do you want to talk about the exceptions, and then I'll take it over after that?
Okay, so Rick just told you about how being very circumspect about taking executive session minutes, and it's important to just keep the bare minimum, and now I'm going to contradict it in three particular circumstances. And that is because there are outside forces, particularly the IRS, that wants you to keep more detailed records. And if you do so, in these circumstances, they will be given weight and importance by the IRS. The first is that, as you may know, the IRS is very concerned about executive compensation. In particular, they want to make sure that executive compensation is not excessive. And if you do have excessive compensation, both the individual receiving the compensation and the people who approve it could be subject to penalty taxes by under the Internal Revenue Code. So in order to provide some degree of comfort and safety for the nonprofits so that they don't run afoul of these rules, the Internal Revenue Code has a safe harbor, which if you follow the safe harbor, the nonprofit, the IRS will have the burden of showing that the compensation is improper instead of the other way around. You don't have to prove a negative; they get the benefit of having to prove the negative. So, and there are certain steps that the IRS wants you to take in order to take advantage of the safe harbor, one of which has to do with documentation. So basically what the safe harbor is that you have to show that the individual, like say your CEO, is being paid what comparable people are being paid for comparable work at comparable organizations. It's beyond the scope of this session to talk about what is comparable, but leave it be. One of the requirements is that the minutes document the method used for determining compensation. The IRS essentially says, okay, it's great that you said you looked at comparable compensation and you followed the safe harbor, but we want you to prove it. And the way to prove it is to keep a good record in your minutes of what you did. So they want you to put in the minutes, the terms of the compensation and the date it was approved. They want you to put in the minutes who the board, or if you're having it done by the executive committee or some other organization, or some other subgroup like a compensation committee or something of the board, they want you to say who was present and who voted on the transaction. They want you to specify what comparability data you relied upon and how it was obtained. For example, if you hired a compensation consultant, or if you looked at compensation surveys, did you look at compensation surveys? What surveys were they? What did they say? Or if you looked at 990s of other organizations, what other organizations did you look at? What was the range of salaries that you looked at? Essentially, they want you to put in writing your thought process. And if any of the board members or the decision makers had a conflict of interest, you had a board member who was related to the CEO, or had someone who worked for the CEO, or whose independence could be questioned, and the IRS has rules about who has a conflict of interest. They want you to disclose in the minutes that this person had a conflict of interest and they left the meeting, or they didn't participate in the meeting, or, and they want you to put that in writing. And as we said before, they want all of this done contemporaneously, meaning basically within 60 days of the meeting, they want it written down. Because the IRS is clear that if minutes are documented later, they want it contemporaneous because they're more credible than if you do something 6 months or a year later. So in that case, they actually want pretty specific minutes so that they can see you step by step what you did to comply with the safe harbor. Similarly, because of the rules with the IRS about using assets only for charitable purposes, if you have a conflict of interest transaction, for purposes of the IRS, you want to show them that you followed a similar process. Conflict of interest transaction is a business transaction between the nonprofit and an officer, director, one of their close family members, or a business entity controlled by them. And typically, a conflict of interest transaction must be approved by a majority of the disinterested directors, i.e. people who don't have an interest in the transaction. And similarly, the minutes have to reflect who has the conflict of interest and what it is. You would say the vice chair was owned the accounting firm that we were going to hire, or was a partner in the accounting firm. You could say so-and-so's son was a partner in the accounting firm that we were going to hire, things like that. And you want to also say, does the board decide, is there a conflict of interest? And if so, was the name, who was present for the discussion, i.e. was the person with the conflict, did they leave the room? The content of the discussion, including whether you looked at alternatives. For example, let's suppose you are hiring the accounting firm and one of the partners of the firm is the son of a board member. You would say we looked at four different accounting firms, we got bids from them each, and this was the low bid. And so what you do in the minutes is you say we looked at these 4 firms, here was what they bid, and clearly this firm had the lowest bid. So that type of detail. And then again, a record of the votes taken, including the vote to approve the transaction. And again, what the IRS is looking for is they want to see a step-by-step process to show that you followed the right processes to approve the transaction. And then the final one is indemnification of directors. There's a lot of rules under DC law about the step process. That's important, but for the IRS, same thing. This is essentially, and when you vote to indemnify a director, i.e. they're sued because they are a director and you want to pay their costs of the litigation, their defense costs and any judgments against them. That's a conflict of interest transaction, so you have to essentially follow the same drill. Who is seeking the indemnification? Who's present for the discussion? Did the director qualify for indemnification? And a record of the votes taken. Again, it's because of the nature of the potential for a conflict, the IRS and also state law wants you in the minutes to show step by step how you dealt with the situation so that it can see that all the T's were crossed and the I's were dotted. So I turn it back to you, Rick.
Okay. We talked a little bit about, but as we finish what Regina just said, one of the things, to the extent you have counsel available to you and you're dealing with any of those exceptions that Regina talked about, you should certainly consult with counsel on how best to deal with the issue, how to document the issue, make sure that you're following the proper steps so that you comply with both the federal rules as well as local rules in connection with those particularly sensitive issues. So to just conclude on the executive session minutes, we did talk about, I mentioned these a little earlier, the best practices. You would keep the set of minutes separate from your regular board minutes. You would note that when you went into executive session in your regular minutes and when you came out, and that would be what you'd have in the regular minutes. And you would keep those executive session minutes limited in their circulation and in a confidential place so that they would not be found and disseminated beyond the group that was in the room for that session. So we kind of covered that a little bit previously. So the next thing that we're going to talk about is some special considerations when you're talking about membership organizations in DC. And again, this talks about the minutes, and this gives certain people the right to inspect board minutes. If you have a nonprofit organization that has members, the members have the right to inspect the board minutes, which could include the executive session minutes. So that here are the rules. It's the 3-year rule for full board minutes, and if it's beyond 3 years, it's the special request that can be made to see the minutes if they show good faith for a proper purpose. And the member can only see excerpts of the minutes relating to the matters that they've requested if it's beyond the 3-year window. So there are some limitations, but clearly you need to be sensitive to the fact that that some of these minutes can be seen by board members. There are exceptions to the extent that the minutes reflect privilege between attorneys and the board. There are ways in which you can get the courts to deny the obligation to make those minutes available to people on a case-by-case basis. But you do want to just be sensitive to the fact that if you have members, then they have the right to see the full board minutes, and the question of the executive session is part of a full board meeting. So there are some, if we can go to the next slide, about ways that you can try to address some things differently. Because in DC, the members do not have the right to inspect the minutes of committee meetings. They're only entitled to see a record of any actions taken at that meeting. So we've talked a little bit about, for example, CEO compensation discussion in executive session. You could potentially have a compensation committee that deals with compensation issues separately from the full board, and those minutes would not be subject to review by members, only the actions taken by those committees. So if you're concerned about things that are happening in executive session and members getting access to them in ways that you're not comfortable, you could consider using a committee structure to try to manage the exposure on these sensitive topics. You should, like I said, consider discussing these sensitive matters in the committee session rather than in an executive session as a way of avoiding potential issues with disclosure. And if it has to be discussed at the full board, whether in the full board and executive session or otherwise, you just, again, need to be very careful about the way you put those minutes together, make them as refined as possible, no more detailed than necessary, so that if the minutes were read by a broader audience, there wouldn't be anything in there that the board or the organization would have a problem with. So there is a fine line of trying to walk between addressing the important issues of the organization, managing the confidentiality of those discussions, and properly documenting those discussions in your minutes. These are just some mechanisms and things that you can use. So that's about minutes. The second thing we wanted to talk about was the myth that there's no voting in executive session. A lot of folks think executive session is simply a discussion area, and if you want to do anything, you have to come out of executive session and take the action at the full board meeting. That is not true. You can take action in executive session. The same rules apply in executive session that would apply otherwise. You need to have a quorum of the board, and you need to call for the votes the same way. Following the executive session, you can, another way to do it is to do the vote in the open session and the discussion in the executive session. But again, you're talking about confidentiality, and so you may want to try to finish the results in executive session and simply report out the action, but there's no affirmative obligation to vote in an open session. So that gives us the right to go into executive session to vote. The question of whether or not you actually want to take votes in executive session really depends on what you're talking about in executive session. What is the culture and background of the organization that you're working with, that you have in your organization, and whether or not there's concerns of transparency if there are actions taken in executive session that are not taken in the full board. So there are a lot of boards that will discuss things in executive session, tee up the board for a decision, but take the decision in the full session of the board and put it in the regular board minutes to show the action taken. But in particularly sensitive areas or areas that you really want to watch confidentiality, you may decide to actually take the action at the executive session, and that would be permitted. You would take the minutes in the executive session similar to the way you would take them at the board meeting in the minutes of a regular board meeting, and you would just keep those approvals separate and confidential in the same way you would the rest of the minutes from those meetings. The next myth is whether there is a duty to disclose everything that happened in executive session. We spent a lot of time talking about all the confidential and things that will happen in executive session, and the idea of having to then disclose everything to everyone afterward seems to undermine one of the points of the session. So discussions and decisions made in executive session do not have to be disclosed in open session. So there's no obligation to disclose. However, again, this comes down to managing transparency in the organization. The question of how do you communicate certain decisions or discussions that happen in an executive session with the CEO or with others on staff, really you should determine case by case. So it may be in the best interest of the organization that you do come out of executive session and the chair sits with the CEO and discloses some of the discussion that happened in the session as a way of trying to advance the interests of the organization. And so that's really a kind of a case-by-case thing. It depends on the relationship between the board and the CEO and staff, and also the topics that were discussed in the executive session. And so, again, we're trying to keep confidential things that are discussed in there and use the information really just to advance the interests of the organization as the board sees fit. So the last item, the myth that we had talked about at the beginning was the attorney-client privilege question. And how do we protect some of these discussions in executive session with the attorney-client privilege? So just to give you the background, the attorney-client privilege is what you use to protect confidential communications between an attorney and his or her client in connection with litigation. So it's non-discoverable communication. It's limited at any time, including executive session, as we said, to having your lawyer in the room acting as the organization's lawyer. I said earlier, just because you have a lawyer on the board does not mean that the discussion is subject to privilege. It has to be an attorney who's actually acting primarily as the organization's attorney in the discussion of the issue. So if it's a litigation, you would want the attorney that is actually representing the organization in the litigation or in connection with consideration of the litigation in the room in order to preserve privilege with the board members in the discussion. Note that it doesn't protect the underlying facts. It only protects the strategic advice and the legal discussion that happened as part of that discussion. If you have non-board members or executives in the room, let's say that you had the auditor in the room or you had a consultant in the room, there is a question of whether that would break the privilege because you now have the attorney, the client, and a third party in the room. So it is probably best, if you're going to be discussing litigation, for example, that you not have anybody in the room other than the board, CEO, and the people who are the company, if you will, and the attorneys, so that you can make sure to preserve that privilege as needed. And if you have to disclose to a third party, then the privilege will protect the communication with the attorney, but not beyond that. So I'll just stress the importance. If you think that you're in a litigation posture, make sure you consult with your attorney before you have a bunch of discussions about what to do next, particularly if you're having those discussions with people who are outside of the organization, because you may end up being in a position where you thought you were having privileged conversation that ends up being discoverable in that case. So the last thing we wanted to talk about before we would open up to questions, and I'll talk a little bit about this, and then I'll ask Regina to follow on with any other practice tips that she had. But these are just some general thoughts and concepts around the use of executive session. The first is many boards do meet in executive session for all the reasons that Regina mentioned. There was a study not too long ago which showed that 70% of nonprofit boards met in executive session at some time during the year. You tended to see them meet in executive session as the revenue of the organization went up. So the more complicated the organization, the more of them used executive session. If you had a smaller organization, sometimes those organizations didn't need to use executive session, didn't see the importance or have the issues that they tended to do, or maybe they had a committee structure. So it is fairly routine to use executive session. So then the next question is, how should you set up an executive session? And you could make it a routine component of your meetings. There are a number of boards that say every meeting of the board, we're going to have an opportunity for executive session. Maybe we'll have a part of that with the CEO. Maybe we'll have a part of it without the CEO. And by doing that, what you do is you institutionalize the use of executive session. If there's nothing to talk about, then you come back out of executive session fairly quickly. But this way you don't create a red flag perception that something is going on in the organization that has caused the board to want to do something different, something special. That usually makes staff uncomfortable that the board is trying to address an issue. And so if you do call them on an ad hoc basis, sometimes people can feel like there's a red flag that's going up. The second reason for considering a routine is that people will come to expect the time in their board meetings for this. It gives a predictable forum to discuss. The board can be thoughtful about the topics that it discusses in these meetings, again, without having to do it ad hoc or last minute, where things may not be as well planned and therefore as helpful. And the other important thing in these types of routine meetings is that you stay on topic, because a lot of times people will go into executive session and things may devolve into gossip or into things that are not really advancing the interests of the organization. So whoever is chairing the executive session, there really should be topics that are going to be discussed in the session, and that it should be limited to those topics and not spill over into things that should rightfully be discussed at the open board meeting, or things that are not helpful in advancing the interests of the organization. Remember, though, there is a group of commentators that are sensitive to the use of executive session. Their concern is that you should keep these to a very minimum, that it throws a cloud of secrecy and suspicion on the activities of the organization, that there's a lack of transparency that can generate distrust within the staff and the organization. So you do want to be careful about how you use the sessions. A lot of it depends on the type of organization that you have. Are you the type of organization where the executive director is very strong and the board is very weak, or is it the other way around? Do you guys share opportunities and obligations? And so the use of the executive session is a bit case by case based on your organization. There is no one-size-fits-all with respect to how you might want to use it. And the last point that I'll mention in connection with the use of executive session is adopting board policies to govern the process of conducting the meetings. And it's beyond just the process. It is the how the meeting is going to be called, who has a right to call it, what is the agenda of those executive sessions, who has the right to ask for things to go on the agenda. Your bylaws could provide a general right to go into executive session. It could provide for special rules for what can and cannot be discussed in executive session. You can have a separate set of executive session rules that are governing that topic. So the important thing about it is, particularly if you're going to institute a routine executive session program within your board meeting, having rules of the road will allow that session to be brief, to be limited to the things that are necessary or appropriate to be discussed within an executive session, not to devolve to things that should not be discussed in executive session. And it gives your board the comfort that when they do proceed on topics of discussion, that they have followed the rules, that they're within the parameters that are outlined by the organization for executive session, so that they can be comfortable that the topics being discussed are appropriate for the session. So those are my general thoughts on practice tips. Regina, I don't know if you have others that you wanted to add as well.
Yeah, like I said, our board routinely went into executive session simply because it was a big board. It didn't meet that frequently, and the directors didn't feel they knew who was in the room, and so because of that, they really didn't feel that they could speak candidly, and so they at some point instituted. It was more of a board bonding experience than anything else, and oftentimes, like I said, it was unstructured, so they did not have to do it. I got to sit in a lot of executive sessions because I was the general counsel of the organization, which is how, when we had a board meeting in Cleveland, everybody else went to see the Rock and Roll Hall of Fame, and I had to stay in the board meeting. So it's not always a fun thing to do. But so I would say that just think about it as less of a an ominous thing and more of a routine part of a function of the board to get a chance to get to know each other, work with each other, feel more of a cohesion. And that's one of the benefits of them sort of getting together as just a board. And the executive session is not the only way to do that, but it's one of the main ways to do it. And it's a board, and if used appropriately, it really does strengthen the board. So that's the only thing I would say. So we do have a couple of questions. I have a couple of questions for you, Rick, and we have a couple other questions. The first is, I just want to clarify something I said that I want to make clear. The first is that if you have someone leave the meeting because they have a conflict of interest, that can be done in either an open session of the board or an executive session. I've seen both. We had a board member who was also the board member of a sister organization that we were working with at Habitat, and we were voting on whether to approve making a grant to that organization. He left the meeting, but staff was not kicked out of the meeting. So in open session, the board voted to approve the transfer even though he had left because he had a conflict of interest. But typically, the more common thing is the conflict of interest is a sensitive matter, and in addition to having that director leave the meeting, you may also ask the staff to leave the meeting as well, so that it's done in private. And that may be a case where you announce after the executive session what happened in the session, but one is different from the other, and so you can ask someone to leave an open meeting, one where other people are present, or you can decide that because of the sensitive nature that gave rise to the conflict, that everybody should leave other than the directors. And so that's the difference between the two. And then the other question that I'll turn over to you, Rick, is, so you're voting in executive session. Like say you're setting the CEO's compensation, you're not going to do that in open session. You're going to do that in executive session. And so the question is, when you do that, when you pass a resolution doing something in executive session, does the resolution look the same? Is there anything special, or is it just like any other corporate transaction? You know, someone makes a motion, someone seconds it, et cetera, et cetera.
Yeah, I would think it's the same as any motion that you would take any other time. It's just in executive session. It would go in the executive session minutes. You would show the board took the action and made the resolution and the vote the same way that you would. It's just that you would put that in the minutes of the executive session rather than in the regular session, and then that would be the support for the authorization of the company to move forward with that particular transaction or matter.
Okay. The other thing is, you know, you talked about it. It's not a gossip session or a gripe session. I guess you know, in your experience working with boards, you know, I mean, how do you prevent it from being that, to devolving into that sort of thing? You know, what are some sort of tips that the chair can use to sort of, as you say, keep people focused?
Sure. So the first thing that you try to do is have an agenda for the executive session. That will initially put limitations and controls over what is expected to be discussed in the session. So that does a lot of good in putting some guardrails on the discussion. The second thing is that when you present, the chair presents the issue for discussion, the issue should be framed in a way that is encouraging fruitful and beneficial discussion without extraneous. So there's a way that you can ask the question or frame the topic for discussion, whether it's in executive session or otherwise, that encourages a robust conversation at an appropriate level. And then the last thing is, to the extent that the chair views the conversation or discussion going off the rails, at that point the chair should gavel the executive session to order and redirect the conversation. Just like any other time in a board meeting, if there is too much discussion or sidebars, the chair needs to get control of the meeting, and the chair has the same right within executive session if the topics that are being discussed or the issues that are being presented are not appropriate for the meeting, and there's just ways to kind of move past that and try to redirect the board to get to the answer or the issue that's really the subject of the conversation.
I was going to say one other thing that I had a great chair called Edgar Stace. He's Edgar Stace, and he was a great chair, and he used to have this rule called no raw meat, which is you don't just take a piece of raw meat and throw it on the floor of the board, you know, so have at it. And what he meant by that is, if something was going to be particularly contentious, which executive session discussions tend to be because they're sensitive and difficult, you know, you may talk to certain people beforehand, you may have a committee work something, you essentially work the issue before the meeting so that at least some of the anger or vitriol is taken out of the discussion before you get into executive session, so that, you know, people have had their chance to vent before the discussion, maybe one-on-one with the chair or something like that, rather than having it in the executive session. That's when it occurs. And, you know, he really was good at just, he saw something was going to be difficult, he called the people who he thought would have the most problems with it and let them vent to him one-on-one rather than in front of the whole board. So I pass on Edgar's advice. Anyway, with that, we do have questions. If you have follow-up questions, please email me there. As I mentioned, the slide the slides are available in the interface. You can look at them. Let me just double check to make sure there's no other questions left. I think that was the last question. And so with that, we are recording this webinar. You will be getting an evaluation with a link to the recording, so please fill it out, and if you want to go back and listen to it, please do so. And with that, we say good afternoon. Thank you, Rick, for your time and expertise. We appreciate it. And thank you all for participating.